Hi everybody. Today's Facts in 5 video is about life estates. So what is a life estate and when would you want to use one? In an estate planning context, there's a lot of different reasons why folks might want to implement a life estate. But again, before we get to that point, you really need to understand what a life estate is. And put simply, a life estate is a right to reside in a property. So if you want to transfer your home to someone else, to your children or others for various reasons, you can reserve a life estate, which means you retain the right to continue to live in the property. So even though somebody else may own the property, you have the legal right to continue to live there. And generally, when you have these life estates in place, even though someone else, again, is the owner of the property and you just have the right to live there, you still are going to be responsible for the carrying costs for the property. So you're still going to have to pay the taxes and the insurance and the utilities and all the other general expenses that go along with the upkeep and maintenance of the property. So from a day-to-day standpoint, nothing's really going to change, even though you're transitioning ownership to somebody else. So when might you want to use a life estate? So first, a lot of my clients who really want to make sure their assets avoid passing through probate like this life estate setup, because probate is only going to be required for assets that you own when you pass away. If you've transferred ownership of the property to someone else but retained a life estate, for probate purposes, you're not going to be deemed to own that property, so it's not going to be subject to probate administration. So that's one time people might implement a life estate like this. The second time people may implement a life estate, or I should say the second most common reason why I see folks implementing life estates, is for potential preservation of assets from long-term care costs. So if you're getting older and you think it's becoming more and more likely that you might need to go into an assisted living facility or a skilled nursing facility, and you don't want your house to have to be sold to pay for all of those costs, one thing you can do, again, is to transfer the house to your intended beneficiaries or to your children, for example, so that they're going to be the owners. And you're still going to have, again, the legal right to live there. But if you have to apply for Medicaid, let's say down the road, and in order to become eligible for Medicaid, they really say you have to spend down all of your assets, well, you won't own your house anymore. So that's one asset that you've managed to protect and pass along to your intended beneficiaries. There's a lot of intricacies to that. So again, be aware it's not just as simple necessarily as just transferring the house to your beneficiaries. There's certain other guidelines that you have to comply with if you're looking at Medicaid eligibility. But again, just generally speaking, if you don't own the house at the time you have to apply for Medicaid, that's not an asset they're going to count against you and again force you to sell. The biggest question I get a lot of times with these life estates is, are there going to be any tax consequences for me or for the people that I'm transferring the real estate to? And generally the answer is no for the people that you're transferring the real estate to. This is not anything that they're going to have to report on their income tax returns or that is negatively going to impact them typically from a tax standpoint. For you, it may mean you have to file a gift tax return, because anytime you gift an asset to someone that's valued at more than $16,000, you have to report that gift to the state of Connecticut and to the federal government. The good news is likely that there's not going to be any tax due at the end of the day, just because typically speaking, instead of state of Connecticut or the federal government making you pay any gift taxes, what they do is instead reduce the amount of your available estate tax exemption by the amount of the tax instead. So currently in 2022, for example, the Connecticut estate tax exemption amount is $9.1 million. So instead of making you pay a gift tax when you report the transfer of the house, they instead reduce the amount of your $9.1 million exemption again by the amount of the tax. So yes, there's a tax component in that you have to still file that gift tax return to report the gift, but you're likely not coming out of pocket to pay any taxes. This type of transfer to beneficiaries during lifetime is also, with a retained life estate, is also going to leave those beneficiaries in a good tax standpoint after you pass away. Because if the beneficiaries who inherit your real estate then later want to sell the property, they're going to receive what's called stepped up basis when you pass away, which means their basis in the property for purposes of determining gain or loss is going to be the date of death valuation of the real estate. So whatever that real estate is valued at as of the date you pass, that becomes their basis in the property. So if they shortly thereafter sell it, they're likely not going to realize any gain. So again, it puts them in a pretty good standpoint from that context as well. Lastly, the one big consideration that you really should be taking into account when you do these transfers in the retained life estate of a property is be very careful about who it is that you're transferring this property to. Because once you transfer your house to somebody else, and if, let's say, they have creditor issues of their own, so if they're getting sued or if they're getting divorced, your asset is now one of their assets. So your house can become subject to their creditors' potential claims. Again, worst case scenario, even if those creditors are able to get after your house, they still do not have the authority to terminate your life estate in the property. So that's still going to be protected. But if the overall goal is making sure the assets pass to the beneficiary, you may have not exceeded in that goal just because, again, they have creditors of their own. So just something to be very mindful of.